Apparently, when Tennessee passed a law that states its purpose is to encourage minors to appreciate and not disdain their birth-assigned sex, and that prohibits certain medical treatments for minors seeking treatment for gender dysphoria, but will allow those treatments for other medical reasons, apparently that does not draw classifications based on sex and is constitutional. Why? Because Chief Justice John Roberts says so. That's why. On June 18th, the Supreme Court issued its heavily anticipated ruling in the United States versus Skermeti, a lawsuit challenging a Tennessee law banning certain gender-affirming treatments for transgender minors. In a 6-3 decision divided along party lines and authored by Chief Justice Roberts, the court held that the Tennessee law at issue does not violate the Constitution's Equal Protection Clause and is therefore enforceable. And regardless of what side of the issue you're on, this case provides a fascinating insight into the mental and linguistic gymnastics the court will go through to invoke the standard of review that will best support its desired outcome. Now, the Skermeti plaintiffs, 3 transgender adolescents and their families, as well as a Memphis-based medical provider, brought a pre-enforcement challenge to Senate Bill 1 of Tennessee, the Prohibition on Medical Procedures on Minors Related to Sexual Identity. Enacted by Tennessee in 2023, SB 1 bans the administration of certain medical treatments for transgender minors. Specifically, the bill prohibits healthcare providers from, quote, surgically removing, modifying, altering, or entering into any tissues, cavities, or organs of a human being, or prescribing, administering, or dispensing any puberty blocker or hormone to any minor for the purpose of 1, enabling the minor to identify with or live as a purported identity inconsistent with the minor's sex, or 2, treating purported discomfort or distress from a discordance between the minor's sex and asserted identity. Sex, in turn, is defined as, quote, a person's immutable characteristics of the reproductive system that define the individual as male or female, as determined by anatomy and genetics existing at the time of birth. Now, at the time, SB 1 permitted a healthcare provider to administer puberty blockers or hormones to treat a minor's congenital defect, precocious puberty, disease, or physical injury. The bill's prohibitions are intended to, quote, protect minors from physical and emotional harm by encouraging minors to appreciate rather than, quote, become disdainful of their sex. Now, among other things, the plaintiffs argue that SB 1 violates the Constitution's Equal Protection Clause, which provides that, quote, no state shall deny to any person within its jurisdiction the equal protection of the laws. The 14th Amendment was enacted shortly after the Civil War to combat discrimination and ensure due process, and the amendment's Equal Protection Clause requires the government to have a valid reason for any law or official action that treats similarly situated people or groups of people differently. So to this end, the Equal Protection Clause was instrumental in striking down governmentally imposed racial segregation, for example in Brown versus Board of Education, and laws prohibiting same-sex marriage in Obergefell versus Hodges. Now, in asserting Equal Protection Clause challenges, courts use different standards of review to assess the constitutionality of laws that differentiate between groups of people. Now, the 3 main standards of review are strict scrutiny, intermediate scrutiny, and rational basis review. And the level of scrutiny that a court will apply depends on the type of classification at issue in the challenged law. And as we'll talk about, sometimes the level of review is the entire ballgame. So, for example, laws that classify on the basis of race, alienage, or national origin trigger a court's strict scrutiny and will only pass constitutional muster if they are, quote, suitably tailored to serve a compelling state interest. And that is a very, very high standard. Now, laws that classify individuals on the basis of sex also warrant a heightened scrutiny, and such laws are subject to what's called intermediate scrutiny, under which the state must show that the classification, quote, serves important governmental objectives, and that the discriminatory means employed are substantially related to the achievement of those objectives. Now, in contrast to these rigorous or semi-rigorous levels of scrutiny, there's what's called rational basis review or rational basis inquiry, which is a deferential, relaxed standard of review that applies to laws that do not burden a fundamental right or target a suspect class. And for the most part, most laws would fall under this particular level of review. Under a rational basis standard, the court will uphold a statutory classification if there is any, quote, reasonably conceivable state of facts that could provide a rational basis for the classification or the law. So basically, under rational basis review, if there is any plausible reason for the challenge governmental action, the court's inquiry is, quote, at an end. So basically, if the court is reviewing something for a rational basis, that law is almost certainly going to pass. If the court is reviewing it under strict scrutiny, that law is almost certainly going to fail. And if it's intermediate scrutiny, it could be somewhere in between. It's probably important to note that absolutely none of that is written into the Constitution. Those are just the rules that the Supreme Court has come up with, but it has been using some version of that for, say, the last 100 years or so. But the reason that we're talking about all this is because the main issue in the Skermeti decision was which standard of review the court should use to assess the constitutionality of SB 1. This is a critical question as the standard of review is often case determinative. If SB 1 created classifications based on sex, then the Supreme Court must apply a heightened scrutiny to the law, either intermediate scrutiny or strict scrutiny, and possibly strike it down unless the court's prohibitions are substantially related to important governmental objectives. And if SB1 does not create a sex-based classification, then the deferential rational basis standard of proof applies, meaning that the law will be upheld as long as there is any rational basis for it. Spoiler, it's clear that this court is not going to consider transgender individuals a protected class. And frankly, time will tell if they're going to roll back protections for other currently protected classes. But taking a bird's eye view of the current media landscape surrounding transgender rights issues makes the possibility of political and cultural influence impossible to ignore. So I want to take a quick moment to thank our sponsor, Ground News. Not only do they give an invaluable tool that we use to research our coverage, but they've been a longtime supporter of our mission to demystify and explain the law. I particularly love that Ground News gives me an insight into the broader cultural and political dialogue about the law that I wouldn't get if I only got my news from a few sources. Here we see that trans rights is one of the most frequently covered topics, with over 700 stories published in the past 3 months, split equally between left, center, and right-leaning sources. And when you examine the headlines using their built-in features, you notice some interesting patterns that give clues into the minds of the Roberts Court. A few months ago, the court upheld that Trump could ban transgender people from serving in the military. This was a big story with about 450 sources reporting, with 25% coming from the left, 25% coming from the right, and 50% coming from the center. And headlines and coverage varied greatly depending on the source. On the left, sources said that the court ruling was backwards, bigoted, and bad, or framed it as a favor to Trump. In the center, sources largely focused on reporting that Trump's ban was allowed to go into effect. But on the right, the ruling was largely seen as a cultural victory against the, quote, paralyzing distraction of Marxian woke activism. And these stark differences show how media bias can influence everything. And that's why I love Ground News. The Nobel Peace Center called Ground News, quote, an excellent way to stay informed, avoid echo chambers, and expand your worldview, and I couldn't agree more. Not only does Ground News gather related articles from around the world and across the political spectrum, so you can see the bias and compare coverage, but every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. And it's because of features like this that make Ground News my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code that's on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the bias insight tool and blind spot feed. So click now or scan the code, or I'll see you in court. Now, the plaintiffs asserted that the Supreme Court should apply a heightened standard of review to SB1 because the bill relies on sex-based classifications. But Chief Justice Roberts disagreed, stating that SB1 does not classify on any basis that warrant heightened review. Specifically, Roberts opined that SB1 does not classify on the basis of sex, but rather classifies solely on the basis of age and medical use. Because, in Roberts' opinion, SB1 merely prohibits the administration of puberty blockers and hormones to minors for certain medical uses regardless of minor sex, it is subject to only the rubber stamping of a rational basis review. Quote, on its face, SB1 incorporates 2 classifications. First, SB1 classifies on the basis of age. Healthcare providers may administer certain medical treatments to individuals 18 and older, but not to minors. Second, SB1 classifies on the basis of medical use. Healthcare providers may administer puberty blockers or hormones to minors to treat certain conditions, but not to treat gender dysphoria, gender identity disorder, or gender incongruence. Classifications that turn on age or medical use are subject only to rational basis review. So in his opinion, a law that allows specific medical treatments to remedy early onset puberty or congenital defect, but does not allow the same medical care to treat trans kids suffering from gender dysphoria, is not based on gender classifications and therefore deserves deferential review. The majority decision emphasized repeatedly that SB1 is subject only to a rational basis analysis because the bill, quote, does not prohibit conduct for one sex that it permits for the other. The fact that these issues by their very definition do not affect members of the cisgender population didn't factor into the calculation. And Roberts' majority opinion further rejects the plaintiff's arguments that SB1 creates sex-based classifications by defining the prohibited medical care based on the patient's sex. And generally speaking, intermediate scrutiny had been used in the past to strike down laws that preferenced or disadvantaged one sex over the other. But Roberts' majority opinion further rejects the plaintiff's argument that SB1 creates sex-based classifications by defining the prohibited medical care based on the patient's sex. In this regard, the plaintiffs maintain that the bill prohibits certain treatments for minors of one sex while allowing those same treatments for minors of the opposite sex. For instance, under the bill, a minor whose biological sex is female cannot receive puberty blockers or testosterone to live and present as male, but a minor whose biological sex is male can, while a minor whose biological sex is male cannot receive puberty blockers or estrogen to live and present as a female, but a minor whose biological sex is female can. This, the plaintiffs argued, dictates the availability of medical care based on a person's sex, creating a sex-based classification requiring a heightened standard of review. The decision, however, dismisses this argument on the basis that the plaintiffs are contorting the meaning of the term term medical treatment by overlooking the underlying medical concern the treatment is, quote, intended to address. Per the majority's reasoning, the intended usage of various medications should control whether their prohibition creates a sex-based classification. Chief Justice Roberts states, quote, "The Food and Drug Administration approves drugs and requires that they be labeled for particular indications. The disease or conditions that they treat, prevent, mitigate, diagnose, or cure. Different drugs can be used to treat the same thing. Would you like Advil or Tylenol for your headache? And the same drug can treat different things. Take Dayquil to ease your cough, fever, sore throat, and/or minor aches and pains. For the term medical treatment to make sense of these various combinations, it must necessarily encompass both a given drug and the specific indication for which it is being administered. When properly understood from the perspective of the indications that puberty blockers and hormones treat, SB1 clearly does not classify on the basis of sex. Both puberty blockers and hormones can be used to treat certain overlapping indications, such as gender dysphoria, and each can be used to treat a range of other conditions. These combinations of drugs and indications give rise to various medical treatments. When, for example, a transgender boy, whose biological sex is female, takes puberty blockers to treat his gender incongruence, he receives a different medical treatment than a boy whose biological sex is male who takes puberty blockers to treat his precocious puberty. SB1 in turn restricts which of these medical treatments are available to minors. The majority also declined to address the plaintiff's separate argument that SB1 requires heightened scrutiny because it discriminates against transgender individuals as a quasi-suspect class, which is a group of people who have historically faced discrimination and are therefore entitled to a rigorous standard of review. In response, Roberts writes that, quote, "This court has not previously held that transgender individuals are a suspect or quasi-suspect class, and that the present case does not even raise that question because SB1, which includes, quote, only 2 classifications of age and medical use, does not classify on the basis of transgender status." Now, in reaching this conclusion, the court relies on the infamous case of Geduldig versus Iao, a 1974 sex discrimination case that concluded that discrimination on the basis of pregnancy does not constitute discrimination on the basis of sex. Geduldig challenged a California insurance program that excluded coverage for disabilities arising from pregnancy. In upholding that insurance program, the court had explained that it did not exclude any individuals from coverage eligibility because of sex, but rather removed pregnancy from the list of compensable disabilities. The court said there, quote, "The program divides potential recipients into 2 groups, pregnant women and non-pregnant persons. While the first group is exclusively female, the second includes members of both sexes. Because women fell into both groups, the program was held not to discriminate against women as a class." Drawing a parallel between the California law and SB1, Chief Justice Roberts wrote that SB1 does not exclude any individual for medical treatments on the basis of transgender status, but rather removes one set of diagnoses, gender dysphoria, gender identity disorder, and gender incongruence, from the range of treatable conditions. Along these lines, SB1 divides minors into 2 groups, quote, "those who might seek puberty blockers or hormones to treat the excluded diagnoses, and those who might seek puberty blockers or hormones to treat other conditions. The first group, quote, includes only transgender individuals. The second group, in contrast, encompasses both transgender and non-transgender individuals." Based on this finding, Roberts concluded that SB1 does not draw a line based on transgender status. All I'll say is that there were very good, very obvious reasons why Geduldig and its reasoning was rarely cited since it was decided. But the Scrimeti plaintiffs also argued that the Supreme Court's decision in Bostock versus Clayton County demonstrates that SB1 is a sex-based classification subject to heightened scrutiny. In Bostock, the Supreme Court held that an employer who terminates an employee for being gay or transgender violates Title VII's prohibition on discharging employees because of their sex. The plaintiffs argued that under Bostock, SB1 discriminates on the basis of sex because it penalizes members of one sex for traits and actions that it tolerates in another. The court reaffirmed the reasoning in Bostock as applied to Title VII, but declined to expand its reach to cases arising from the Equal Protection Clause. The court stated the quote, "We have not yet considered whether Bostock's reasoning reaches beyond the Title VII context, and we need not do so here because, unlike in Bostock, changing a minor's sex or transgender status does not alter the application of SB1. If a transgender boy seeks testosterone to treat his gender dysphoria, SB1 prevents a healthcare provider from administering it to him. If you change his biological sex from female to male, SB1 would not permit the hormones he seeks because he would lack a qualifying diagnosis for testosterone, such as a congenital defect, precocious puberty, disease, or physical injury. Under Bostock, quote, neither his sex nor his transgender status is the but-for cause of his inability to obtain testosterone. So after rejecting all the plaintiffs' proffered reasons for applying heightened scrutiny review to SB1 because it classified based on sex, the Supreme Court proceeded to analyze the bill under the permissive rational basis test, concluding that, quote, SB1 clearly meets this standard. In support of this conclusion, the court stated that the bill's classification based on age and medical diagnoses were rationally related to the purported findings about the risks associated with administration of puberty blockers and hormones, and the objective of protecting minors' health and welfare. And the court dismissed the plaintiff's arguments that, per the court's own reasoning, such gender treatments may also carry comparable alleged risks for cisgender minors undergoing treatment unrelated to gender dysphoria. Quote, "We afford states wide discretion to pass legislation in areas where there is medical and scientific uncertainty. The fact that the line might have been drawn differently at some points is a matter of legislative rather than judicial consideration." Justice Thomas concurred with the majority's decision, asserting that Bostock was wrongly decided, and in any event, there was, quote, "no reason to import Bostock's Title VII analysis into the Equal Protection Clause." Justice Alito also concurred, finding a strong argument that SB 1 classified on the basis of transgender status, yet agreed that the classification would not warrant heightened scrutiny, concluding that neither transgender status nor gender identity is a suspect or quasi-suspect class. And Justice Barrett also filed a concurring opinion arguing that transgender status should not be recognized as a suspect class, an issue that the majority opinion did not address. Which is important to point out, this particular opinion didn't quite go as far as it possibly could have, so it doesn't completely rule out the possibility that status as being transgender is a suspect or quasi-suspect class, which would entitle laws that discriminate on that basis to heightened review, which would make them more likely to be struck down. But I would not expect this court to make that finding anytime soon. But in support of Justice Barrett's conclusion, she stated that transgender people were not marked by, quote, "obvious, immutable, or distinguishing characteristics as race or sex," and were, quote, "an insufficiently discrete and insular minority that had not proven a, quote, long-standing pattern of discrimination in the law." Barrett indicated that she would not recognize any new suspect classes absent a sufficiently voluminous history of legal discrimination. Justice Sotomayor dissented, joined by Justice Jackson, stating that SB 1, quote, "expressly classifies on the basis of sex and transgender status, warranting intermediate scrutiny," and that the bill would fail that analysis. Justice Kagan joined most parts of Justice Sotomayor's dissent, but stated she reached no conclusion about whether SB 1 would satisfy heightened scrutiny. But Justice Sotomayor further stated that the majority's decision, quote, "invites legislators to engage in discrimination by hiding blatant sex classifications in plain sight." Referencing Barrett's opinion, Sotomayor explained that, quote, "those searching for more evidence of de jure discrimination against transgender individuals need look no further than the present. The federal government, for example, has started expelling transgender service members from the military and threatening to withdraw funding from schools and nonprofits that espouse support for transgender individuals." Now, apart from the dissents, many legal commentators have criticized the Roberts Court on the basis that it is outcome first, or rather that it determines the conclusion it wishes to reach and then forges legal avenues to arrive at that destination. And it does require some mental gymnastics to look at a law that specifically targets transgender youth and find that it doesn't target transgender youth. As the court famously stated in a 1993 opinion, a tax on wearing yarmulkes is a tax on Jews. But the majority seemed to go out of its way to ensure that the law would receive an easy blessing under the rational basis review. Additionally, critics have pointed out that the decision addresses the equal protection challenge in a vacuum without acknowledging the parents' due process right to direct the care, custody, and control of their children, thus appearing to violate states' rights over parental rights. As recognized by the Supreme Court in a case called Troxel versus Granville, the interest of parents in the care, custody, and control of their children is, quote, "perhaps the oldest of the fundamental liberty interests recognized by this court." The Troxel court invoked this due process right in striking down a Washington law allowing broad visitation rights to non-parents, noting that, quote, "there is a presumption that fit parents act in the best interest of their child, and that, quote, there will normally be no reason for the state to inject itself into the private realm of the family to further question the ability of that parent to make the best decisions concerning the rearing of that parent's children." And this right has been recognized in the context of parents seeking medical care for their children. The Scarametti plaintiff's certiorari petition was based in part on the argument that, quote, "SB 1 is an attempt by the state to inject itself into the private realm of the family in violation of Troxel." And in the state law context, the Ohio Court of Appeals recently held in Moe versus Yost that an Ohio law banning gender-affirming care for transgender minors violated the Ohio Constitution, where the law infringed on the substantive due process right of the parents to direct the care and upbringing of their children under the state's due course of law clause. Now, again, this is limited to one particular state, but in reaching this conclusion, the Ohio court looked to the decisions of the U.S. Supreme Court for guidance, noting that parents have a, quote, "essential and basic civil right to raise their children and a, quote, fundamental liberty interest in the care, custody, and management of their children." So, applying strict scrutiny, the Ohio court refused to hold that the state's interest in protecting children from allegedly dangerous medical treatments justified the categorical ban on puberty blockers and hormone therapy for minors diagnosed with gender dysphoria. Quote, "We conclude that parents have a fundamental right to seek medical care for their children, which naturally includes the right of parents to, in conjunction with their minor child's consent and their medical provider's recommendation, make a judgment that such medical care is necessary." And a third criticism is contrary to the majority's opinion. The facts of Scarametti appear to fit squarely within the prohibition on animus against a politically unpopular group. In Romer versus Evans, where the Supreme Court struck down a Colorado constitutional amendment preventing protected status based on homosexuality or bisexuality, the court explained that, quote, if the constitutional conception of equal protection of the law means anything, it must at the very least mean that a bare desire to harm a politically unpopular group cannot constitute a legitimate governmental interest. And the Romer court held that Colorado's amendment didn't even satisfy the rational basis test because it was a, quote, status-based enactment divorced from any factual context from which we could discern a relationship to legitimate state interests. And the court concluded that the amendment classified people not to further a proper legislative end, but rather to make them unequal to other citizens. Further, as the court explained in holding the Defense of Marriage Act unconstitutional in United States versus Windsor, the design, purpose, and effect of the challenged law should be considered in deciding whether a law is constitutionally valid and not motivated by animus. In particular, the court noted that, quote, a desire to harm a politically unpopular group cannot justify disparate treatment of that group, and that discrimination of an unusual character requires especially detailed consideration. Now, unfortunately, there is nothing that I can do about a Supreme Court decision, but I can help some of you if you have suffered a personal injury. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who were dealing with legal problems. People would DM or email and ask if I could help them find a lawyer, or how do they know if their attorney was any good. And there's just a massive gap in our justice system. It's not just that legal help is expensive, though it absolutely is, it's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up either doing nothing or hiring the first attorney who calls them back. And that really bothered me. And so I asked myself, what if there was a different way? What if we could build a law firm that actually lived up to the values I talk about on this channel: transparency, accessibility, and putting clients first instead of just chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix the problem. I decided to start my own personal injury law firm, and honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. And that's why we started the law firm Eagle Team. Not to get rich, trust me, there are easier ways to make money than starting a law practice, but we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer, you're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, not just whoever happens to be available, located right where you are. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, or a social security or workers' comp issue, give us a call at the number on screen or click on the link below. I can't represent everyone who watches this channel, I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partner with, you'll get the same principles of honesty and education that we bring to every video. So if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about. Making sure that when life gets complicated, you don't have to face it alone. Which is why, if you need a lawyer, you don't just need a legal team, you need the Eagle Team.